I'm Emily Westhofen, Executive Director at the German American Business Council. It's my pleasure to offer this event and presentation here today that we are actually recording. So for those I know who will be joining later, they have the ability to actually look back and see what was said in the beginning. Today's presentation on innovation protection and innovation rights with patent attorneys, both from the US here and Germany. We're excited to offer this today with Susan Glovsky and Alexander Adam of Hamilton Brook Smith Reynolds here in Boston, and Christoph Karl, patent attorney in Munich. I have a couple of housekeeping items for you, mostly to share. We are a smaller group this morning, so we want to make sure this is personal and informative. So if you have, during the presentation, have any questions, actually feel free to chime in and ask your questions. You have the ability to unmute yourself and ask. If you feel more comfortable putting a question into the chat, you can also do that. And there will be opportunity at the end of the presentation to ask questions too. So we just want to make sure that you do have that ability to ask the questions. We also have a couple of polling questions that will pop up on your screen once the presentation starts. Feel free to answer those. Just, a little bit of gauging here and there where you stand with some knowledge on patents. And I think, without further ado, I will be handing it off to Susan Glovsky, who will make the formal introductions of the speakers here today, and then we will launch into the presentation as well. So welcome everybody, and Susan, it is your turn now.
Thank you very much, Emily. And on behalf of Hamilton Brook Smith Reynolds and Alexander Adam and me, we appreciate the opportunity that the German American Business Council is providing us to feature what we do and to introduce Christoph Karl, who is in Munich, an attorney we work with on our patent applications and patent applications that he has. Today's topic is strategic focus on innovation and rights enforcement, and we should move to the first slide. Thank you.
I think.
And the next slide.
We're going to launch the first polling question, right?
Yes. The first polling question, if you could all please answer, do you or your company own any patents? And yes or no. And we have so far 50-50. So that's interesting. 2 yes, 2 no. I am a member of the board of the German American Business Council. I'm a principal at Hamilton Brook Smith Reynolds. I went to the University of Vermont and studied chemistry. And to introduce Alexander Adam, he is a principal at Hamilton Brook Smith Reynolds as well, registered patent attorney, and he has degrees, multiple degrees from Boston University, a BS, an MS, and a PhD in biomedical engineering, and a law degree from Suffolk University Law School. He has experience in trademark as well as patent work, and he practices in diverse technology. Alex is from Cologne in Germany, and he has been in Boston since starting at Boston University for his bachelor's. Next slide. We only have 4 of you responding to our polling question. Perhaps more of you could give us your answers.
I think we've closed the polling for now. Sorry, Susan.
Say that again.
I think we've closed the polling already.
Oh, we did close the polling. I'm sorry. I didn't realize that. Which is interesting, 50-50 to begin with. Christoph Karl is a partner at Bardila Pagenberg. He has been a partner there since 2010, and he's in Munich, European patent attorney, which I have huge respect for anyone who is a European patent attorney. That's a tough road to hoe to get that credential. University of Munich Law School, George Washington University Law, and he's an attorney at law. He went to law school in the United States and is admitted in New York. And he also went to law school in Germany and is an attorney at law in Germany. His clients include leading US companies in the computer network area. I'm going to now turn it over to Christoph to tell us a bit about patents.
Thank you very much, Susan. Well, as Susan said, and as you can see from my background, I'm the only one not sitting in Boston here from the panelists. And I will start off with a little bit of general backgrounds on patents before I turn a little bit more to the European side of it, and Alex and Susan will deal with the US side of it. So patents provide protections for technical inventions. What technical means, I will come back to later. But I think we can start our second polling question here, which is if anyone here in the audience is actually named as an inventor on a patent or patent application. So far 6 times no. And one of the audience isn't quite sure. I think that's a clear no. So probably don't have a lot of personal experience then with the patent process, and we hope we can provide you some useful background information in today's talk. So patents give a monopoly right, like other intellectual property rights, which is limited in time to 20 years from filing. It is also limited in territory because to obtain protection for an invention, you have to actively register the patent. You have to go to a patent office, describe what the invention is, disclose it to the public, and then if the patent is granted, then this patent is only valid in the territory of the patent office you went to. So if you went to the US patent office, it's only valid in the US. If you go to the German patent office, it's only valid in Germany. If you go to both of them, then you have a patent in both countries. That is different, for example, in copyright, where if somebody writes a piece of music or makes a movie, this protection is automatically granted. There's no administrative act to be done, and it's valid worldwide. So patent protection, if you want to get it, you have to actively do something. Next slide, please. Yeah, a prerequisite of getting a patent is first of all that the invention must be new. And how does the patent examiner know that it's new? Well, he makes a prior art search, and what would be prior art? Really anything that was published in any form, broadly speaking. That could be first of all written publications, so any ideas divulged on a website, for example. That could just be an oral presentation as we're having it today here, or that could simply be by using the invention. So all these activities disclose the idea. And if you could go to the next slide, please. It is important to note that this includes ideas presented by the inventor himself. So if he already has presented the idea to the public, he will in general not get patent protection anymore. That comes as a surprise to many less experienced inventors who come to our office and say, we have a great invention, we want to publish it. We've been using it for half a year now. It's got good commercial success, and now we want protection. And then we have to tell them, sorry, this is too late now because you have already published it. There are some countries that still have a grace period. It's called, most importantly, the United States, where 1 year after the inventor himself published the idea, you can still apply for patent protection, but not in most countries of the world, really. So if you or somebody in your company has an idea that you or your company wants to protect, most importantly, keep it quiet. Before the patent application is filed, it should not be disclosed to anyone. If you do have to disclose it to anyone, have that anyone sign an NDA so that it will not be further published by the third party. Next slide, please. Not only does the idea have to be new, it also has to be inventive. Inventive doesn't have to be a stroke of genius. Inventive means it's not obvious. So it's not trivial. Let's put it this way. For deciding whether something is inventive, actually the prior art from all over the world is being taken into account, independent of whether the inventor himself was aware of that prior art or not. So if you go to the patent office with a great idea and the patent examiner tells you, well, I made a little bit of search and I found somebody in China had a similar idea, you might be out of luck. Although your invention, I mean, the effort was the same, but if somebody had something similar before, you may not get this patent. Next slide, please. Yeah, so coming back to the notion of a technical idea, at least in Europe, it is clearly in the statute that you can get patents only for technical inventions. So what would not be a technical inventions? I put some examples here on the slide. They're not exhaustive. Most importantly, for business methods. So if somebody has a great new idea how to sell products on the internet and lure more customers on his website, that would not be something that he can patent, even if the idea is the greatest business idea in the world. The same is true for aesthetic creations. Copyright and design would be more appropriate to protect those. And there are many examples otherwise. For example, cooking recipes would not be technical. A new technique in your favorite sports, if you invent a new karate move, would not be patentable. As I already said, for some of these non-technical innovations, other forms of intellectual property would be more appropriate. For example, design protection, which in the United States, as Alex will explain to you in a minute, is also called a patent, not in the rest of the world. Copyright, or if it's names or logos or things like that, then a trademark would be the right protection. And with that, I believe I hand over to Susan.
Thank you, Christoph. We do have a little bit of time for any questions if anyone wants to contribute to what Christoph had to say. Hearing nothing, you have to unmute yourself if you're interested in making a contribution. But I'm going to move on. There are all kinds of reasons to get a patent on your invention, primarily because you can't protect it any other way. Because, for example, you are practicing the invention in a way that everybody sees what you're doing, and they will copy it if you don't have patent protection. But if you can keep it secret, it can be extremely powerful to keep your innovation secret. How do you create a trade secret? You keep it confidential. You don't tell anyone. The moment you tell one person your secret, there is the possibility that others will hear it. And it is impossible to let that cat out of the bag. You don't have trade secret protection once everyone knows it. However, you could by agreement try to rein in anyone from disclosing it. So a trade secret lasts as long as you keep it confidential, which can be forever if it doesn't get to other people. Until 2016, in the United States, trade secrets were governed by state law, and I'll get into what happened in 2016 in a moment. Under the Economic Espionage Act of 1996, it is a criminal offense to steal someone else's trade secret, including for the benefit of a foreign government. A trade secret, what is that? Well, it's just about anything. It's a formula, it's a device, it's a process, it's a method, it's a compilation of information that when used in a business gives the owner an advantage over competitors who do not know it. It must be the subject of efforts that are reasonable under the circumstances to maintain its secrecy. So for example, when you take that file to Starbucks and you leave it on the table and you go up and get another coffee when Starbucks opens again for people to come in and sit down, that is not reasonable under the circumstances to maintain a trade secret secrecy. You have to do efforts to protect it. And if you end up with someone stealing a trade secret from you and you try to go after them for that theft, and you didn't take reasonable precautions, you aren't going to be able to enforce your trade secret against the theft. Next slide. So again, trade secrets can be plans, designs, patterns, processes, formulas for drugs, foods, chemicals. The formula for Coca-Cola has been kept secret. There is no patent, it's just secret. And they do all kinds of measures, including only having a couple of people know certain ingredients and another couple of people know how to mix it all in. Manufacturing methods and techniques. Laboratory and engineering notebooks are full of trade secrets. This next one is something that I really like, negative information. No, it's not being a critic of something. It's information that says we've tried 20 ways to solve this problem. And if your competitor learns those 20 ways that failed, that gives them a leg up on trying the 21st method. So that in and of itself, those failed experiments are trade secrets. Computer software, the nice way of keeping computer software protected is not to let anyone else have access to it. And if you can sell your products without providing access to the source code, that can be very, very powerful. Next slide. So in Massachusetts, I love this example because I love chocolate chip cookies, and I particularly love Peggy Lawton chocolate chip cookies. And there was a lawsuit, and the owner of the recipe, Peggy Lawton, kept that recipe secret. It was in a drawer. It was carefully guarded. There was one copy locked in an office safe. A duplicate was in a desk. Satisfied customers who said, "I'd like the recipe," were told no. But an individual in the company wrote down the formula, and the case decided that that was, in fact, a trade secret that was stolen. For workday use, the individual broke down the formula into baking ingredients, small ingredients, the secret nut dust, and bulk ingredients. And the three components were kept on separate cards that contained gross weight. So each of the ingredients was on a different card, and the person who owned the company separated access to that set of cards so that there was one group with access to 1, 2, and 3. So even though the cards were concealed, the true portions of the ingredients, access to the cards was limited to longtime trusted employees. But one person did figure out a way to gain access to each of the items, put it all together, which is how there was a lawsuit in Massachusetts that determined trade secret law based on a cookie recipe. Imagine representing our clients who have all kinds of very sophisticated inventions, and we're being guided by a case involving chocolate chip cookies, which is not always analogous to technology for determining someone's fingerprints or DNA, but that's what we have as one of our guideposts in Massachusetts. Next slide. So I told you that things changed in 2016. Defend Trade Secrets Act was enacted, and you might notice that we just had the 5th anniversary. May 11, 2016 was the date it went into law. And the other day I was reading news about all kinds of intellectual property things, and I came upon the fact that it was the 5th anniversary. And I liked this quote because I totally agree with it. Someone said that 5 years later, the DTSA changed everything and changed nothing. So let's take that apart. What it changed that is most significant and that I particularly like is that being a federal law as opposed to a state law, it allowed you access to the federal courts. And I personally prefer to be in federal court for a trade secret case or other cases for lots of reasons. It certainly depends state to state. We have 50 states, 50 sets of laws, and sometimes you might be representing one side that would do better in a particular state. But a lot of times the federal courts have more organization, better funded, and cases move more beneficially in the federal court. So it also created a federal system of trade secret law, which you might think, okay, well, that's a huge change. How can you say it changed nothing? Well, that's because all those federal judges that are interpreting this federal law have already been interpreting their own state law. And at no time do you start enacting a statute or a law from scratch. You always are using some language from a state law or language borrowed from a different state to create this federal law. And those judges have been interpreting those words in a particular way, and Massachusetts judges might be interpreting them differently from California, from Montana, from Chicago, Illinois. So lots of times now we found over the last 5 years, there have been decisions that are similar and not as consistent as one might like across the country. The statute also, it is important, may have global reach. And in fact, there have now, over the 5 years, cases have to work their way up through the courts and get decided. And one case, an Illinois federal judge ruled that the DTSA should be read as a cohesive whole that applies overseas, and he found in favor of Motorola against a Chinese firm, and determined that so long as the misappropriator was a US citizen or entity, or an act was done in furtherance of the theft in the United States, the plaintiff can sue under the DTSA. So if what you are doing outside the US has a misappropriator in this way, you can be hauled into the US court. Let's do another polling question. Where are you located right now? I know at least one of you is in Germany, so, and we're not counting the speakers. 2 in Germany, 29% in Germany, 57% in the US, and 14% other. Wonder where that person is. I am going to not only end this poll, I am going to close my sound because I think someone is mowing outside. So I will mute.
All right, can we go to the next slide? So Susan just mentioned a couple of cases where innovations were kept secret. They were not published in a patent. Well, I should maybe mention also that if you opt for patent protection, you cannot keep the idea secret, because the patent application, where the applicant has to describe how the invention works, will be published after 18 months from filing, and therefore any trade secret protection would be gone. You can maybe leave away some details and keep those secret, but for whatever idea you want to have patent protection, if it's on the broad general idea, that broad general idea at least needs to be disclosed. Some of the examples, as the cookie recipe, the innovator didn't have a choice, because there would not have been a possibility to protect this cookie recipe by other forms of IP, at least not in Europe, where we can only get patent protection for technical inventions, and a cookie recipe is not something that would be recognized as technical. But for other innovations that are technical, there is a choice on the part of the innovator or his employer, whether they want to go for patent protection, get a monopoly this way, or whether they want to try to keep it secret. For example, Susan mentioned that software that is not published in source code form, but only machine code, is a good way of keeping ideas that are embedded in that code secret. So the algorithm that this software performs oftentimes cannot be seen, or not even be reverse engineered if you try to, unless you have access to the source code. On the flip side, if you nevertheless say, I would like to get a patent on my new algorithm, for example, it's an algorithm that makes access to a database faster, twice as fast as Google. That is something that is technical, can be patented, but maybe you don't get a lot of benefits from this patent protection, because you yourself could not see whether any of the competitors actually uses this algorithm. If Google reads your patent application, says, hey, this is really working, we implement it in our machines, you will one day notice, well, Google has got faster, but you have no idea why they got faster. Maybe they came up with an alternative algorithm. Of course, Google is also innovating all the time. So that might be then a case where you say, well, let's maybe try to keep it secret. Other reasons not to opt for patent protection include you may in the end not get the patent because the examiner finds prior art which renders the invention not novel, was already known, or it is something very similar was known. In this case, if the search report by the patent office comes out early enough before the patent application is published, which is after 18 months, the applicant can still withdraw the application, and then it will never get published. Another big advantage of trade secret protection is it's free. It doesn't cost a penny. Doesn't cost any time, only the time to make sure that the secret remains secret, and it doesn't cost you money for patent attorneys, us, and also not for patent office fees, and how much that is, we will see a little later. Next slide, please. What would then be the advantages of patenting and not opting for trade secret protection? Well, I already mentioned that some innovations you would not see that somebody's using them. Other innovations, you have to disclose them. There's no possibility. I give you one example. Apple has a patent on the slide to unlock feature, which is not being used anymore in the recent years. But I'm sure you remember that slide to unlock feature where you had to move your finger like this, and then it unlocked. Apple still has that slide to shut down feature. That is something that obviously you cannot keep secret if you want to use it and sell it to your customers. Even if you have the possibility to keep something secret, as we could see in the cookie recipe, where all sorts of measures were being taken, extreme measures, I must say, to keep it secret, that wasn't successful in the end. And in today's industry, if you go to Silicon Valley, you know, an engineer that is today working at Google, tomorrow is working at Apple, and then 2 years later, they switch to Facebook. And they can take all these secrets with them. And it's, I think, you know, the times where, like my father, he worked all his life for Siemens, started with Siemens, and he retired with Siemens. Those days are over. So how successful is it to keep a trade secret secret? Depends, you know. If the competitor pays a little more, the secret must, for the employee, secret may be gone together with the employee. In Germany, at least everything that the employee takes with him in his memory, that would be okay, is not protected by any trade secret protection. If he takes with him a lot of documents, because it's too complicated to take this information just in your memory, that would be a trade secret protected. So there is legal means then to sue, for example, the new employer for using this this knowledge. But if it's a simple idea, and the simpler ideas are oftentimes the best ones, that can be just stored in the memory, employee is free to take it with him. Next slide, please. I already mentioned before alternative intellectual property protection. There is in some jurisdictions, and that includes Germany, a smaller brother of the patent, which is called a utility model, where protection only runs for 10 years from filing, not 20 years. It has much lower costs, though, because the office fees are much more reduced, and also there is no examination procedure. So the patent office will simply take the application, put it on the register, and there is no discussion with the examiner about novelty and inventive step. Such a discussion would then be held once the utility model is used. Once you use that model to sue somebody, then that defendant would typically raise the defense of that wasn't inventive, that wasn't novel. But to register it in a quick manner, this is a very cheap form of protection, but still it is very similar to patents. Not like patents in Europe is a registered design. So if, let's say, it's a new part of a car, the outside of a car, or a new design of a telephone, you could simply register that a picture of that new design, and then get a certain form of design protection, which is a little bit similar to copyright protection, but copyright protection is oftentimes not available for such articles as a telephone or a car part. Already mentioned trademarks. Trademarks typically protect names, protect logos, and obviously they do not have to be new or inventive or particularly aesthetically pleasing or special. Next slide, please. Wrapping it up, is it worth applying for patents? Yes or no? Following questions might be ticked off in your head. First of all, will others want to imitate it? If it's something that is only meaningful for your own company, no use in running for patent protection. Can infringement be detected? So if somebody else uses it, will you become aware of that? Yes or no? We have a lot of clients, in particular startup companies, that say, I know I don't get a meaningful protection for my idea. Maybe the monopoly would be very narrow. Maybe it's easy to circumvent, but I nevertheless want to say to my investors, we applied for a patent, or we have a patent, because that will, give them some security. They feel much better than investing in our company. If you come to the conclusion, well, this idea is not important enough for us to go through the efforts of patenting, or we, for some other reasons, don't do it, you might want to publish the idea anyhow, because if you don't patent it, somebody else might. And if that somebody else patents the idea, you can't use it anymore either. You can prevent that somebody else gets a patent on it by publishing it, because then the idea is not novel anymore. It's so-called prior art, and nobody can get a patent on that anymore. IBM, until a few years ago, had a disclosure bulletin where they put in all the ideas that their engineers had and where they decided not to patent it. And they published this bulletin once a month or so. And it was always a great resource for patent examiners for prior art. So that really, really worked. Okay, next slide, please. Yeah, I already said patent protection doesn't come automatically. One has to go to a patent office and file a patent application. In Europe, things tend to be a little bit more complicated than elsewhere. The same is true for patents. We don't only have national patents, so there's not only a German patent office or a French patent office or an Italian patent office. There is also a European patent office, and which issues European patents, and the applicant really has the choice to go for a European patent or for a national patent. A European patent is worth the effort, roughly speaking, if protection is sought for 3 or more countries. If it's just 1 or 2, it would be cheaper to go to national patent offices. So I see there is a question. Oh, and now it's gone again in the chat. Why are already more than, okay, this was another question that was just for my information. All right. So I will speed up a little bit. The European Patent Office actually does not issue a patent that is then valid in all of Europe. It's it still such a patent granted by the European Patent Office would still have to be validated in the different member states. So there might be a German part of the patent, a UK part, and a French part, and the more parts the applicant wants, the more money he would have to pay. Can we go to the next slide? This is a map of the countries participating in the European Patent Office, and you can see this is not identical at all with the European Union. And in fact, the European Patent Office has nothing to do with the European Union. As you can see here, the UK is a member of the European Patent Office, or Switzerland or Norway. For all these countries, a patent can be obtained through the European Patent Office. Next slide, please. This is an overview of the countries that the applicants choose for nationalizing the European patents. And the big three are Germany, France, UK, which is simply the biggest markets in Europe. And in fact, 50% of the applicants only choose those three jurisdictions for nationalizations for cost reasons. Next slide, please. Here you have an overview that is an estimate made by myself that may not apply to other firms or not in every case. But roughly speaking, the costs for obtaining a European patent from drafting to grant of the patent is about 20,000 euros. After that, that is not all. You would also have to pay money for each country where you want to validate the patent. And then you also have to pay an annual fee to the Patent Office for keeping the patent alive until it expires after 20 years, which is can also be substantial. Next slide, please. With that, I hand over to Alex.
Thank you, Christoph. So I don't know if there were any questions for Christoph, but we can also answer them at the end. But feel free to enter them in the chat or unmute yourself and ask a question. But what I wanted to briefly talk about is that the timing of filing patents internationally. So, for example, we can start with the patent that's first filed in the US. That may be a provisional patent application, which is a peculiar application that can be filed in the US. It doesn't get examined, but it gives you a placeholder. State claims your rights. And within 12 months, you then have to file a regular application. That can be a so-called non-provisional US utility application, or if international protection is desired, the applicant may file for an international application under the Patent Cooperation Treaty, or PCT. Again, this must be done within 12 months from the priority filing date. And I've indicated on this graph here some errors. So the black arrows are patents that first start in the US and then get filed through the PCT in other countries, for example, in Europe. So the PCT application will be searched for prior art and examined, but it does not itself mature into a patent. Instead, the applicant at about 30 months, so about 2.5 years after the priority filing, must decide which countries or regions now patent protection is actually to be obtained. And national and regional filings need to be made. And for that, for example, if we start in the US, we would then engage with patent attorneys around the world to accomplish that. And for example, if you start in the US, then file a PCT and after 12 months, and then within 32 months, you have 32 months in Europe to file a European regional application. I would then call up Christoph or email him and say, Christoph, we have this application. Our client would like to file in Europe. And he would then take the information and complete the filing in Europe. And that's quite often that our clients go this way, that we start out with the provisional application in the US, then file a PCT application, and then file, for example, in Europe. Other countries that see frequent filings are China. There you have 32 months to file. And you can also go back from the PCT and go file a regular US application at 30 months. Now, conversely, if Christoph files an application first, for example, in Europe, and this is indicated by the red arrows in this slide, he could then file a PCT application again within 12 months and then send the information over to us, and we would handle the US filing. And we will work with Christoph and his clients on seeing the US application through to issuance of a patent. Now, if you want to directly file in Europe and not go through PCT, there's also a treaty, the Paris Convention, and that's possible. So within 1 year of filing your first application, for example, in the US, you can go directly to Europe. And sometimes that's interesting for clients who don't want to see protection all over the world, but just specific countries. Or, for example, you could directly file in Germany. The Patent Cooperation Treaty covers most of the world, but there's some countries that are not included, that are not members. One notable exception is Taiwan, which comes up quite often in the semiconductor-related industries. So for that, you would have to directly file in Taiwan within 12 months of your priority filing date. Let's see, let's move on to the next slide. So here's an example of an actual US patent. That's the first page of the patent. And this is a patent we obtained for Christoph's client Ascom, which is a global provider of telecommunication solutions. And this relates to estimating a relative angle orientation between a person and the mobile device that the person is carrying. So you can see that this was first filed in Europe in 2014 as a PCT application. We then handled the US national stage filing about 2.5 years later in 2017, and 2.5 years later, it issued as a patent. So next slide, and I'm looking at the time, and I might have to speed through my slides a little bit. So as I mentioned, patents are a monopoly, so it's a grant by the government for exclusive use of an invention, and it's 20 years from the filing date for these patents that we typically think of. For design patents, as they're called in the US, the term is 14 years. To enforce rights, you really need an issued patents. There are some limited rights available to the applicant upon publication. And one important thing to note is typically it's first to file who gets the patent around the world. And the US came on board to that kind of concept in 2013. Still, it's called first inventor to file in the US because the US places emphasis on the inventors. And so before that time, the US was a first to invent system. So it didn't matter if you beat someone to the patent office. If you could show previously that you were the first one to invent, you could still get the patent. Next slide, please. So just quickly to review. So in the US, we have utility patents. These are what you typically think of a patent. They protect mechanical, electrical, chemical inventions, and by statute, it has to be a process, a machine, a composition of matter, or a combination thereof. We do have design patents, and they protect the ornamental appearance and not the function of an item. As we had explained earlier, Christoph said it could be the new iPhone shape or a car part. We also have plant patents for particular types of plant that can be reproduced asexually. So these are the three patents. The utility patent is the most common, but design patents have seen some popularity with some infringement cases that were in the millions of dollars in the US. Next slide, please. These are just the legal requirements. As in other countries, you have to have novelty, and the patent has to be inventive, which in the US is called non-obviousness. And all of it is measured with respect to the prior art that is out there. That is what is known. And let's move to the next slide. So, as already briefly touched upon, why are businesses interested in patents? Well, it can establish an exclusive position for the business. And Also, it can create value for investors, for venture capitalists, for bankers, for joint venture partners, et cetera. As Christoph mentioned, startups may be interested in obtaining patent protection or have a patent pending to then show that to their investors or potential investors, that there is some protection available. It offers a bargaining position against third parties that may want to enforce their own patents. So basically you say, look, I have my patents, you have yours, let's come to an agreement, let's not sue each other. It can produce additional source of income via licensing. So you may want to protect your own products via a patent, but you may also license the technology to others. So they may, with your permission, produce a product or use a method that's patent. And lastly, you can prevent others from claiming the same subject matter just because the patent is out there and published. All right, I think it's time for our last polling question here. So question number 1, how many US patents have issued today? What do you think? Is it 1 to 5 million, 5 to 10 million, or is it more than 10 million? Oh, nobody wants to guess. Oh, there you go. And the second question is, what year was the first US patent issued? Was it in 1790, or was it in 1836, or in 1911? Oh, I think we're, oh, here we go. We can't getting some more answers. All right. Well, answers are coming in. We can move to the next slide. So the first patent was issued in 1790, and here's an image of the first patent. It was actually issued to a Philadelphia-based businessman who had developed an improved method of making potash and pearl ash. And these type of ashes are used in industrial processes and as a fertilizer. So it's very simple. It's a 1 paragraph with the signature. This was the first patent. Notably, this was not patent number 1. Next slide, please. So if in your answer you picked 1836, you're partially correct because the patent number 1 was issued in 1836, and that was for a locomotive steam engine for railroads and other roads. And it's particular at a time, 1836, when rail construction in the US was starting to expand. And the invention relates to a cogwheel that provides more tractive power to the locomotive, as shown in the image there. And the inventor, notably, this John Ruggles, was from Maine. So he probably experienced how these locomotives slipped in the winter, and he wanted to provide a better traction for these engines. And then the last year that was on the poll, and some of you picked that, that was actually the patent 1 million, and this was in 1911, and it went to a Francis Holton from Ohio. And shown on the left, this was for an improved vehicle tire. And that was less likely to puncture. And basically the tire was, half of it was solid rubber, and as you can see in the bottom picture, and half of the outer surface of the tire had these ribs in it that provide some cushioning. And this was an alternative to a pneumatic tire, so it couldn't puncture. All right. I think a lot of you guessed right that we had more than 10 million patents. In fact, the patent number 11 million issued last Tuesday, and that was for a method of delivering and positioning a prosthetic heart valve. So we can see over the years how the focus of the technological development has changed from fertilizer to steam engines or railroad traction cogwheels to tires for cars, and now we're into heart valves and heart replacement medical devices. And that, I think, concludes my part, and I'm going to hand it back to Christoph. And thank you.
And I'm going to interject first that if we have questions, Christoph is going to move into enforcement. We just have a few minutes left. And I, having spoken to Christoph beforehand, if you do have questions, we can move to those. If not, we can use the next 4 minutes for discussing enforcement in Europe. Any questions? Jan Schilke, unmute yourself.
Hello. Just have one question. Just if you could advise me, for someone who just have a rough idea and wants to engage with someone, potential investors, what would be the best way to protect your idea? I mean, it's clearly not at a stage where it would be patentable, but like you said, you want to prove that you have used all the measures to protect it, but maybe would be a non-disclosure agreement, would that be enough, or are there any other ways that you can just secure and can securely talk to someone?
As a first question, where are you?
I'm in Munich as well, actually.
You want to talk to Christoph?
Yes.
Yeah.
Hi.
NDA is the best way to do it. Actually, if that person that you talk to then discloses the information to somebody else, so the genie's out of the bottle, then you're still out of luck. But you can sue your potential business partner for breach of the NDA. I mean, other alternatives would just be to leave information that the partner doesn't need to have, leave it away, describe it in a more abstract way. But if you have to disclose the information and otherwise you won't get the business, then you have to do it. And I mean, a serious business partner will, of course, honor the NDA and not disclose it then to anybody else.
And you also have the opportunity, either in Germany or if you are in the US, to file a patent application. It might not stand the test of time. You might 6 months later realize that you don't have the money to invest or in the excuse me, patent, but it is a good preemptive thing to do. And in the US, we have provisional applications for those of you who are in the US. Other questions?
Absolutely.
Thank you.
Sure. And you certainly need the last slide. So let's move to that. And we'll skip through enforcement.
I have a question to Alex. So why was the patent number 1 issued in 1836? It was so before they didn't count, I suppose.
Right. So in 1836 actually was a year when there was a change also overall in the patent laws, and they started numbering it. And there was actually about 10,000 patents between the first one in 1790 and the patent number 1 in 1836. And the guy, John Ruggles, who obtained patent number 1 in 1836, actually was from Maine. He was, I believe, a senator, or a member of Congress, and he actually helped change the law, the patent law. So it was kind of interesting, but he was also an inventor. So that's it. I don't know the reason, but I thought they probably wanted to start numbering it. And they also formalized the patent process. You see there's pictures now in the description, whereas initially patents were more or less just written up, and there were no formal requirements that came at that time.
In Germany, by the way, patent systems started much later, some in the late 19th century.
Oh.
Great, I'm going to jump in here because we're exactly on the hour at 10 o'clock this morning. And I certainly want to really thank the speakers, Susan, Alex, and Christoph from Munich. I don't know if there are more questions. I think, Christoph, Susan, Alex, maybe you have a couple of minutes to stay on for anybody who has a question they would like to ask. We will stay on. For everybody else who has to jump off to their next meeting, thank you for joining us today. And we will make this recording available as well as the presentation and send this to you as our follow-up. Please, if you're not familiar with the German American Business Council Boston, check us out on our website. And for upcoming events, we have a great COVID testing event coming up next week. And so do join us then. And if not, have a great rest of the day here in the US. There's still lots to come, or in the afternoon in Munich. And thank you to everybody. Thank you.